Mr. Chairman, you can begin when you are ready.
Good morning and welcome to the second public stakeholder engagement meeting of the Special Select Committee of the Senate on the Sexual Offences Amendment Number 3 Bill 2021. This hearing will be delayed. The broadcast will be delayed on Parliament Channel 11, Parliament Radio 105.5 FM because of the sitting of the House, but there will be a live broadcast on Parliament's YouTube channel, ParlView. My name is Clarence Rambarat. I'm the chairman of this Select Committee, and I would now invite my colleagues on the committee to introduce themselves.
Good morning, everyone. Renuka Sagram Singh Suklal, member.
Good morning. I am Randall Mitchell, member.
Good morning, Paul Richards, member.
Good morning, I'm Jayanti Lachmidial, member.
Thank you very much. We have 6 groups before us this morning, and I want to first thank them for making their written submissions. We received the written submissions and for appearing this morning before us. And the stakeholders who are before us today are the Ministry of National Security, the Ministry of Foreign and CARICOM Affairs, the Ministry of Social Development and Family Services, the Gender and Child Affairs Unit of the Office of the Prime Minister, the Children's Authority of Trinidad and Tobago, and CreativeTT. I would now invite these stakeholders to introduce themselves, starting with the Ministry of National Security.
Hello, good morning. Thank you for inviting us to this session. I am Shamin Gandhi Andrews, the Chief Immigration Officer.
And Abdul Mohammed, the Legal Officer at the Immigration Division.
Thank you.
Good morning, Chair and members of the committee. My name is Gary Joseph, and I'm the Acting Permanent Secretary, Ministry of National Security. And on our end, I also have Ms. Ragbir, Legal Officer, too. The other members, I would ask them to introduce themselves from the Strategic Services Agency.
Hello, good morning. My name is Sharice Nixon, Assistant Director, Legal Services in the Strategic Services Agency. And I'm here today with the Senior Legal Officer, Ms. Kalisha Bello.
Thank you. And I now invite the representatives from the Ministry of Foreign and CARICOM Affairs.
Thanks. Thank you, Mr. Chairman, and good morning to you, members and witnesses. I am Rita Toussaint, Acting Permanent Secretary of the Ministry of Foreign and CARICOM Affairs, and I will invite my colleagues to introduce themselves to the committee.
Hi, good morning. I'm Sunita Harikisoon, Director of Legal Services here at the Ministry of Foreign and CARICOM Affairs.
Good morning. My name is Shamian Tilal. I am the Legal Officer 2 of the Ministry of Foreign and CARICOM Affairs.
Thank you.
Okay, thank you very much. I now invite the representative from the Office of the Prime Minister.
Good morning again, Chair, members of the committee, and the witnesses that are present. I am Jacinta Bailey Sobers, Permanent Secretary with responsibility for Gender and Child Affairs at the Office of the Prime Minister. And with me I have...
Good morning, Chair, members and witnesses. My name is Anne-Marie Kwame Aline, Coordinator of the National Policy on Gender and Development. Thank you.
We also have our Director, Legal Services. Could you introduce yourself, Ms.?
Good morning, Mr. Chairman and members, and Other present persons, my name is Nisha Cardenas Rossand. I'm a Director of Legal Services at the Office of the Prime Minister.
Thank you, Chair.
Okay, thank you very much. And we would be joined shortly by the representatives from the Ministry of Social Development and Family Services and by the representative from CreativeTT. I see Mr. Lewis. Mr. Lewis is from OPM, right?
Mr. Lewis is he's not going to be attending.
Okay, all right. So thank you very much.
We also have the Insurance Authority Chair, which is under our remit to say.
Right, so thank you very much. And I want to proceed with the discussions that the stakeholders would engage in with the committee members. And I want to first invite my colleague, Senator Paul Richards, to, or in fact, I want to invite member Jayanti Lakshmi Diyal to lead us off.
Thank you, Chair. Good morning, everyone, again. So I'll start with the submission we received from the Ministry of National Security. What stood out to me, and thank you very much for your submission, but in the cover letter, what jumped out at me is you're raising sort of the issue of what we call nanny cams, and in common language. Basically, what I'm understanding is you're saying that someone may actually be committing all the elements of the offense inadvertently if they install something in their home and they say it's for security purposes, but it could perhaps be used for voyeurism. Am I reading correctly into what you're basically raising here? Anybody from National Security can answer.
Miss Nixon, was that comment made on your end?
It's in your letter, PS, signed by you. Let me just say it here, there's one scenario that may arise that may pose some difficulty for a victim, where a homeowner installs security cameras or hidden cameras within his home for the purpose of voyeurism of persons he invites into his home as contemplated, but installs same under the guise of security monitoring as contemplated by section 22(3)(c). So the homeowner in such a situation may fulfill all elements of the offense of voyeurism, but has a full defense for the crime. So this is the letter sent under your hand, PS. It's included in that cover note. And then there's some section by section comments as well. So I'm asking now, is this specifically what you're saying is that if someone were to install cameras inside of the home and they capture a private act, you think that they may be able to raise defense saying that it's for their own security, even when the person who is committing the act is invited in?
Well, just 1 second, I remember. Ms. Ragbir, are you on?
Yes, I'm here.
All right. Could you respond to that submission?
Yes, that is correct. It was contemplated, the situation with nanny cams.
So do you have any suggestion, or have you all considered any other options that could prevent such or do you have any suggestions for how we could treat with that issue within the bill?
So far, we haven't had any suggestions quite as yet. We had just raised the issue to determine if this would be something that would be contemplated, that would be covered by the particular sections. But we were still trying to figure out a way in which it could be worded to be able to circumvent that particular issue.
Mm-hmm. What's your view on creating something within the act that would prevent persons from having monitoring in private areas of the home, where you would expect a proper, so the bathroom, for example, something like that you basically prohibit. I mean, it's sort of imposing that there's a balancing issue there of rights. It's you're imposing telling someone what they can do in their private home, but it's also that because they invite someone in, the expectation of privacy. Do you think that would be sufficient to cover it?
Yes, that can be sufficient to cover it. However, you correctly raise the issue of privacy, whether that would infringe rights to privacy and all that. Maybe something along the lines of preventing hidden cameras, maybe like you said, in certain areas of the home, as well as probably cameras that can't be seen by the naked eye or something like that. I'm not sure if that might be a viable suggestion.
Sorry, Paul, go ahead.
Could I ask a related question here through you?
I give way.
Yes, Member Richards.
Yeah, does the team at the ministry feel that there could be the inclusion of the requirement for the owner of the home or premises to declare that the premises is monitored in some way by a camera, so that there's an understanding that, well, you should not expect privacy in X area because I'm surveilling my private property for my purposes of whether I want to protect my child or protect my property from invasion, etc. And if that could be included as some sort of caveat and documented that the person understands this, so they don't inadvertently expose themselves and put the owner in a liable position. As is done in some jurisdictions where you see, I know it's kind of a wide stretch, but this area is surveilled by CCTV camera. It's usually on premises walls, but in a private home, it could be a discussion or documentation that when you take on the job, you know the home is surveilled by CCTV cameras or cameras to protect their children.
Yes, member, I do think this could be an option that could be available, at least given a heads up as to the presence of cameras on the premises itself. That could be a way that we could work around the provisions of the bill in looking at that.
Right. One other thing, Priyanka, when we talk about, challenge with that is people who install surveillance inside their home, they usually don't want the nanny, the caregiver, to know that it's there, because that's the whole point, is for them not to know that they are being watched while they care for children or whatever. But a key element of the offense really is that the proof that what is being done is for the purpose of obtaining sexual gratification. So, I mean, I would think that would be the defining line between genuine nanny cam monitoring as opposed to, looking at someone, depending on the location of it. If it's not, even if what ends up being captured ends up being something that could be sexual in nature, if there was no expectation that sort of thing would happen, let me be very blunt and very frank. You have a monitoring system in your house because you're looking at, you want to watch and see what's happening with your child during the day, and you didn't know that the babysitter is inviting the boyfriend over to, spend the day with her, and you end up capturing something you don't expect. But in a place in your home that you don't expect, is that, there's no intent on the part of the homeowner to capture these images for sexual gratification. So do you think that the bill as it is clear enough that once that element of for the purpose of sexual gratification is there, that it's satisfactory?
I think so. Remember, I think in a situation that could be covered by the bill, but what we had contemplated when we were looking at that general comment is a situation where the homeowner themselves might be, the cameras would be installed for the overt purpose then of monitoring, the child and how the babysitter would take care of the child. But then there's a hidden covert purpose where the homeowner themselves may be using it for like some sort of sexual gratification. Or like the voyeurism itself. So the situation contemplated by yourself just now, that could be covered, I think, by the provisions of the bill itself. And there are, an offense could be made out in a situation like that. However, sorry, an offense can be made out in a situation like that. But in the other situation where the homeowner themselves are using the camera, the homeowners are using the camera for that particular purpose, that is the one that we were still having discussions about.
Okay. All right. So we'll flag it and perhaps have a look at it a little bit further. Okay. So moving on. Immigration. I know Mrs. Gandhi Andrews is on. The definition as
Well,
it currently
just before we move on, because there's another issue that the ministry raised about the word reckless. Could the office identify what the issues would be with the being reckless there?
Sure. The word reckless, and considering the Canadian Criminal Code specifically made reference to the word reckless, and it was a suggestion for this to be included as well, which would contemplate situations whereby the provision could cover situations where the offender themselves, they are careless about obtaining the consent of the person. However, it is noted that section 22C, 22C1A did contemplate that the situation whereby the offense would be committed without reasonably believing a depicted person consents. That could cover all situations, but the inclusion of the word reckless was just to cover like a more specific scenario where the person was careless about consent.
Thank you.
Now, as Senator Richards jumped forward to that one, let me just ask you, Rianka, a situation like that, though, if you include someone being reckless about the sharing of the image, we have this situation now where everybody forwards things on WhatsApp and it's forwarded multiple times. You could have a scenario arising there where you would have hundreds of people perhaps being guilty of the offense. Because how does anyone, when you receive a WhatsApp message, know whether or not the person consents to their image being shared, whether they themselves put it out there or whether they, so recklessness. So you understand the challenge with placing something. I understand I understand the reasoning behind it. Of course, you want it's not an image that's put out there by the person and you don't want it to be shared. But how does anybody know when they receive things in this form whether a person is consenting, whether this person voluntarily made this video or took these photos and wants it to be out there or whatever? So it raises that issue of, and I have my pet peeve is putting things on statute books that really just can't be implemented or cannot be enforced or cannot be, you can't get a conviction on it. So I'm just wondering about that sort of a clause. How do you anticipate being able to prosecute people for this offense if you include that element of being reckless as to consent?
Yeah, I understand. I think what the thinking behind that was just to cover all different types of scenarios given the issue we have these days with pictures and videos and stuff being shared on social media. But I understand the point that is being made, and it will be difficult to prosecute in a circumstance like that. I do think that the bill as it is drafted could cover a wide range of scenarios with the inclusion of that provision where it said without reasonably believing that the depicted person consents. So the inclusion of the word reckless is neither here nor there, I think. I just think it was just for clarification and the more specific situations.
No, it certainly, it would be perhaps useful in the case of the person who initially obtains the image and shares it. But as I said, it would also be applicable to anybody who is sharing it. And what you don't want to have, perhaps, or at least in my perspective, you don't want to have that the one person who doesn't even know this person, doesn't know anything about it, no malice or whatever intended, but they get this thing and they think it's interesting and they forward it, that they could actually be prosecuted under this. I mean, everybody should probably, be more responsible, but at the end of the day, it's the person who triggers it is the person you want to go after, and perhaps it just doesn't make, I don't know, it would be a bit of a storm brewing if everybody who shares something is captured by the act, right?
Yeah, understood.
Okay, so yeah, back to the definition section with the immigration, the definition of law enforcement officers. You all thought about including immigration officer. However, as you all correctly noted, there's that subsection F, any government agency that has investigative powers. Do you think it's necessary to be more specific and include immigration officers in the definition? Do you anticipate that would pose a challenge if they weren't included? Or, I mean, I'm neither here nor there about it, but I'm just asking if there's anything that, any reason why you think it's absolutely necessary to have it there. Because I'll tell you this, the broader the definition of law enforcement officer becomes, it's the more people that are basically having this exculpatory type thing section applied to them. They have a lot of powers to be able to commit acts and do things, and then it raises the issue of whether they're doing it in the course of their duties and all of that. So just wanted to hear from you on that.
So to just address that point, I believe the intent from our response was to indicate that our interpretation of the interpretation section of the bill, and specific law enforcement officer, seems to include by necessary implication the definition of an immigration officer under the Immigration Act, specifically Section 12 of the Immigration Act. So I don't believe there's any need to specifically identify an immigration officer as a law enforcement officer. I believe immigration officers are covered within the scope of their duties, of course, in the exemption created under the bill.
Okay. All right. So again, perhaps for clarity, if you wish, we could look at including it. I'll ask them to include it in the and we'll have a discussion about it later on. I don't know if anybody else.
Sorry. My simple view is that if no other law enforcement authority is specifically named, I don't think that there's a need to specifically name an immigration officer.
Okay, sure. All right. The ministry also asked about including something that's applicable in the UK. The definition, Reg, you want to just or anybody from the Ministry of National Security, if you all want to give us an indication as to why you believe it was the substitution of the word private parts and naming the parts itself, that you thought that this wording would be more applicable. This is where we're dealing with section 22A1B and the act of the part of how you're viewing the person.
Oh, it wasn't actually it wasn't to substitute private parts for genitals, buttocks, or underwear. It was basically to include this particular line that was highlighted in circumstances where in the UK legislation they had in circumstances where the genitals, buttocks, or underwear would not otherwise be visible. But it's to include that line, but instead of actually stating genitals, buttocks, or underwear as stated there, since we define private parts in the definition section, we could just put it as in circumstances.
You'd want to say in circumstances where the private parts would not otherwise be visible.
Yes, correct. Yeah.
This may actually be useful in cases where, like carnival. I mean,
yes,
people are wearing.
That's what was contemplated by that particular section. Because if somebody takes a video or a picture on carnivals, usually you want to make sure that those types of things would be above board. So this would just further clarify that particular section.
Yeah, because we do have a concern about what, how do you balance what is our culture and the norm of, it's what would be acceptable during carnival days as opposed to normal days, and how do you balance that sort of thing. So
I don't know if Senator Richards answer, because that clause presumes a particular, when you say what would not otherwise be exposed, and we keep referencing carnival, but I am seeing evidence more and more where what we would consider normal dress is getting more and more risque.
Well, it comes back down to the expectation of privacy. And if someone dresses in a particular way to reveal, I guess, certain body parts, then there's no expectation of privacy in a public place. And the photographs that are taken cannot, it's just my respectful view, but if someone takes a photo of you wearing something risky, as you say, Paul, in a public space, and then it's shared, I don't think the act is meant to cover that, because you've, by choice, worn something that exposes particular body parts in a public place. It may still be humiliating to a person if it is that those photos and so on end up on the front page. We don't all dress, whether it's, you know, sometimes it's not even just about you know, the way that you're exposed, it's just the way that you look. You don't always want to end up in the newspaper, but it happens. And once you're in a public place, you run that risk. So that is something that we have to consider, but I don't think the act would be able to address that issue. That's a totally different issue. I mean, with respect to it being a sexual offense, because that's what we're looking at here. I think we just have to find a way to ensure that persons who are unhappy with photos taken of them in a public place, dressed a particular way, isn't prosecuted, because we don't want to over criminalize things that aren't.
I apologize. I lost connection for a second. I apologize.
Oh, I'm sorry. I'm talking about over criminalizing things. And if you're
agree.
dressed in a particular way in a public place, and that photograph ends up being published somewhere or shared, you know, and you don't like it, you don't like the way that it looks, then you ought not. I'm not saying you ought not, but it's this act isn't meant to give you redress for something like that. That's my point. So I think we have
it's people, exactly the point you're making. I remember that we did that. Persons don't use the law for instances it was not intended to be used.
Correct. Yeah. Okay, so we can look at that wording about, I think that's a useful suggestion coming from the Ministry of National Security in the circumstances where the private parts would not otherwise be visible. So we can perhaps look at if we want to use that wording somewhere into the section, so that we will cover the cases where the photograph may, or the video or whatever it is, may be exposing a person, but it's not in a situation where they have that expectation of privacy, because I think we do have to address that. And I guess we'll hear later from other persons. Sure. I think Member Mitchell wants to.
Member Mitchell.
Senator Lachmidial, I completely support your submission. I think it is extremely useful. It introduces a concept of implied consent, where persons dress in a particular way and they go out and they participate in the proceedings, but of course, may feel a different way when photographs are published. And I think it's extremely useful and it takes care of that. What I wanted to ask of national security, and if you don't have the answer now, you can perhaps submit it in writing later on. I know that prior to the carnival period, there are certain legal instruments that are put into effect that decriminalizes certain aspects that are normally criminalized. For example, the wearing of masks and other certain things. I just want to know if that proclamation or promulgation can impact further on persons dressing in a particular way, but for that period of carnival where these items may be decriminalized, that they would not apply. I don't know if national security understands me.
Sorry, could the question just be repeated again, please, just for clarity?
Okay, could you take us through a normal carnival period? There is something that is promulgated, some sort of legal notice or legal order or something to that effect. Could you tell us what that is? The police.
So during carnival time, like you said,
yes, during carnival time.
Yes, so certain things would be decriminalized.
So for example, out of carnival time, it would be a criminal offense to walk around wearing a mask, covering your entire face. I mean, we're in a pandemic now, so mask wearing is allowable. But there are certain things that are criminalized. You can't walk around wearing a mask, for example.
Yeah.
But during carnival period, there is some legal notice that decriminalizes certain things.
Mm-hmm.
And I'm just asking, you don't have to give it now, because I'm sure I'm springing something upon you that you're not prepared to answer at this time. But if you can give us some an answer in writing. Is it possible, for example, for some of these items to be decriminalized during the carnival period for that added level of, I guess, protection against the photographers and other persons, because we live in the digital age, everybody takes a picture and everybody posts a picture, etc. So if you could just give us that in writing.
Yes, sure.
Thank you.
Yes, thank you.
Okay, thank you very much, Member Mitchell. I just want to invite Senator Paul Richards now to lead us off. We have a submission from the Ministry of Social Development and Family Services, and the submission proposes, I want to say, amendments and changes to about 12 parts of the bill. So I want Senator Richards to lead us off with a discussion with the Ministry of Social Development and Family Services.
Thank you, Chairman. Good morning again, everyone. The ministry, in its quite extensive submission, red flagged quite a number of issues. I'd like to start with some of the definition concerns that the ministry has identified, including the interpretation part of the bill, section of the bill, complainant, consent, accused or defendant spouse. And also, the ministry is not the only entity that has flagged the definition of sexual act. And if the ministry can add some clarity to their concerns in these regards, please.
Thank you, Chairman.
Right. Do we have Permanent Secretary, Ms. Johnson?
Chairman, good morning, Chair, members of the committee.
Right, I give you the opportunity before you respond to Senator Richards to introduce your team.
Thank you, Chair. With me today, I have our Senior Legal Officer, Ms. Jennifer Juteram, and Ms. Kathleen Saka, our Director, National Family Services Division. I'm Jacqueline Johnson, Permanent Secretary.
Thank you very much and welcome. So you could proceed with your response to Senator Richards.
Okay, so we thought that at the interpretation section of the bill, we needed to add those definitions that we have indicated there: complainant, consent, accused or defendant, and spouse. We felt that there were some weaknesses in that section in terms of the definition there, and who are these people as defined in the amendments to the bill. The other areas that Senator Richards asked about would include.
If I could just, before you move on, you also added that the complainant can include, but be not limited to, a victim regardless of age, parent or guardian, teacher, child, care provider, social worker, healthcare worker, attending to a minor, and has found evidence of sexual abuse and religious leaders. Do you think that opens the door to possibly a plethora of, and I understand the intention, my understanding of the intention.
The Chair, we thought that the incidence of this kind of activity is widespread, and it may be underreported in a lot of instances, and therefore, in order to protect those who are vulnerable, including the children, we may need to include religious persons as complainant, as well as in the case of a minor, if there's any evidence of found of sexual abuse, it may include voyeurism as well.
But does the Children Act mandate that all abuses against children be reported as a legal responsibility? I'm not sure, I'm not an attorney, but maybe some of the attorney can answer that by my memory of the Children's Act.
Yes, it does, Chairman, and there's a specific area which reflects issues surrounding pornography in the Children's Act. But to keep it tight and to prevent all possible occurrences of these kinds of events, we thought consideration should be given to expanding the group which can make a complaint on this matter.
Is part of your intention to put more of a responsibility on these persons identified to report if evidence presents itself? Is that
yes,
part
it
of the
does.
intention? Okay.
Yes, it does. Yeah.
Thank you. And the part of the word sexual in the act, and I'm going to the definition section. Sexual act means, and I quote, an act which a reasonable person would, comma, in all the circumstances, but regardless of the purpose of a person, considered to be sexual. What is the challenge with that? I think it may be in concert with other acts. It may have been taken from other acts. Is there an expansion of that you have a recommendation for?
I'll just pass to Ms. Juturam to give a little bit more on that issue.
I think we were of the opinion that it could be subjective in terms of what could be deemed to be sexual. So we just wanted to have recommend a little more explanation on it.
I guess
it's subject to various interpretations, and we would just wanted a little more clarity, and so it will not leave any room for misinterpretation.
Okay, understood. Thank you. Also, you cited clause 5, where you had concerns about section A. A person commits an offense of voyeurism if, for the purpose of obtaining sexual gratification for himself or another person, or causing humiliation or distress to a person he knowingly observes, whether with or without the use of equipment, or that a person doing a private act and he knows or ought to reasonably know that the person does not consent to being observed. And you think that's, I guess, too wide, because you say person living in vulnerable circumstances, housing or shelter, which may have visible access inside because of the circumstances of the person, can be violating because their homes are that dilapidated. That you think that, is it that you think that because of the condition of the house, the owner of the house or occupant, the main occupant of the house, may be caught in the offense intended here? Is that the concern?
Because of their particular living situation, Chair, we are of the view that they would have created an opportunity for someone to commit the offense. And our intention there really is to indicate that we may need to look at ways that we can help those people in such conditions so that they do not create the opportunity to be violated. I think that's was our thinking there.
The owner of the premise they're talking about here?
Yes, the person who is living in a dilapidated condition. We see homes where, there are situations where the occupant may be missing walls, parts of walls, windows and stuff like that. And that creates an opportunity for persons to access their privacy. And therefore, the intention here is really not to make any amendments, but to take cognizance of the fact that these situations do occur. And maybe we need to ensure that those persons are also captured, not because of their particular circumstance of not being able to fully secure their privacy, that they are excluded in any way from coverage under the amendments.
Just before I yield to my colleagues, there are other issues I have that I can come back to later. I'm sure my colleagues have other issues with what we've covered so far. Something occurred to me when I read this concern that you identified in clause 5. Do you think consideration should be given to expressly include in the bill persons who may be in extremely vulnerable situations, in some instances, people who are extremely poor or who are migrants or illegal migrants and struggling, that persons may ask them to take pictures, exploit their vulnerability, and use those pictures and say, well, I got permission, but the permission wasn't under duress, but it was under a particular vulnerable state at which a person who is not under that state may not have ordinarily consented.
Chair,
a short circumstance.
Yes, those are some of the circumstances that we thought about. And a good example was some pictures which we saw taken of some Venezuelans who were living in some galvanized kind of facility. And it's their vulnerability at that point that may create some problems here with the legislation, because anyone can see through the facility, and we don't know how they can use those pictures for nefarious types of.
I'm speaking about, if I could, something a little more sinister, where persons are in vulnerable situations, they're invited to a home, and the person who owns the home or property says, you know what, I'm filming this, do you agree? If you don't agree, you could leave. But the person is in such a desperate state that they agree, not possibly having at that time agency, as it were, because of their vulnerability. And they agree to that and have problems down the road. And I think as Ministry of Social Development, and the state, we have a responsibility to protect persons in those levels of vulnerable states from that kind of exploitation, even though they may agree at the time because of their situation.
Yes, that's exactly another case.
I'll leave my colleagues, Chairman, at this time.
Okay, thank you, Member Richards. I want to invite Member Mitchell or Member Sagram Singh Suklal. Do you have any questions for the ministry?
Thanks, Chair. If I may jump in before Mr. Mitchell, it's not really a question, it's rather a comment, right? It's just relative to the concern that the ministry would have had on the definition of complainant, consent, accused, or defendant. I just want to respectfully submit, and I'm sure your legal team would guide you accordingly. But when we look at the mindset or what was considered in the drafting of this bill and the inclusion of the term complainant, defendant, and even spouse, I just want to put forward that the definition of this is already established in the Summary Courts Act, Chapter 420. Even when we look at the Distribution of Estates Act 2000, we would have had a clear definition of what complainant, consent, accused, and so on. So for the purpose of that interoperability of law and to standardize the position, that's why in the current amendment, there was no further amendment made to what the term complainant is deemed as. Of course, of course, the complainant, when we're looking at a complainant and someone who can bring an action, we must also bear in mind the issue of locus standi, right? Simply referring to the fact that once someone can establish that they have a cause of action, of course, that person, whether it's a parent, whether it's a guardian, whether it's a teacher, of course, that it does not prevent, but based on the current definition, it does not prevent any party or parties, once the locus standi is established, it does not prevent the parties or any party from bringing that said action relative to the law in its current incarnation. Now, I just want to also remind or respectfully submit that in Section 31 of the Sexual Offences Act, there is also a list of reporting obligations. So if social development is concerned about persons, the vulnerable persons and persons who has an obligation to put forward a complaint, if you may respectfully revert to Section 31 of the Sexual Offences Act, that that in which there is a list, an exhaustive list, for want of a better word, of persons who have a reporting obligation, especially as it relates to sexual offenses, as it relates to children. So, Chair, that was just relative to those definitions. I just wanted to put that forward, and perhaps the ministry may be minded to consider or reconsider its position in wanting us to further define what a complainant and so on is.
Okay, thank you, Member Sagram Singh. At this time, I want to invite Member Mitchell to lead us off in respect of this submission from the Children's Authority. Member Mitchell.
Thank you very much, Chair. To the Children's Authority, I see in your comments, and I think it was raised before, ensuring that the definition of sexual act is consistent in both the Children's Act as well as in this act that we are now proposing. But do you not accept that both definitions deal with an objective standard of reasonableness in terms of what is sexual and what is not sexual, and in terms of that objective standard, that it is an easy one to achieve and to determine?
Good morning, Member Mitchell. Good morning, Chair, honorable members. Relative to this question, I would wish my Senior Legal Officer, Ms. Satram, to answer.
We're looking at the definition in the Children's Act at section 3(2)(b). And in there, there is an objective standard of reasonableness. And within the definition section in this current amendment bill, there is a reasonable standard as well as to what is sexual and what is not sexual. Do you believe that it is an objective and simple standard?
Good morning, honorable member. Yes, we do believe that what we were trying to aim at is that when it's inserted into the Children Act, that there is no inconsistency in that we don't want to have a dual definition. We want to make sure it flows and is incorporated, because in the Children Act, it is broad enough to incorporate. And it seems to be a reflection, but we just want to make sure that it flows and it's not inconsistent, because we don't want to end up with a dual definition in terms of what the definition for sexual or what considered a sexual activity. So that was the intention with respect to that comment, please.
But do you still believe that there is such a danger? Or is it your position that the committee should consider whether there is a danger in there being a separate definition from the children, from this present bill that we're discussing?
I believe that when it's inserted into the definition, there should at least be one definition. Not that we have to look at what is considered sexual under Section 32 of the Children Act and then go to voyeurism that has what is considered sexual under voyeurism. Just to clarify and to make it simpler, when we are looking at the meaning and interpretation of some of these sections, that would be helpful.
Okay, thank you. So we'll certainly put those to the CPC and ask for their advice. Now, moving on, with respect to persons in a position of trust. Now, we had discussed previously with some different witnesses the concept of aggravating factors and mitigating factors, persons in positions of trust being mentioned. But it is your submission today that in the consequential amendment in new section 8A of the Children's Act, you believe that we should insert or reinsert sections similar to section 29, 30, and 31. Is that your submission? To capture persons in positions of trust, hold them to a higher accountability, and signal that these persons, once found guilty, should attract a higher sentence?
Yes, please. It is our intention because positions of trust, as you rightly said, a breach of that should attract more accountability because just of the very nature of it and the relationship. And when you deal with children, particularly, this is a vulnerable population, and to have that violated, where you have people who should be looking out for them instead, took advantage of that situation. So we just made the suggestion in terms of just having it very specific and very clear, so there's no doubt with respect to voyeurism.
Okay, thank you, Chairman. I think it's a useful consideration. And on to your other comment. Your comment with respect to the definitions of device and equipment, that comment actually touches not just on the consequential amendment 44E to be inserted into the Children's Act, but it also touches on the 22A in the Parent Amendment Bill. Chairman, I wish to submit that I agree with the Children's Authority and that we should use the word device and not equipment. If you look at 22A, 1A, we identify the word equipment, but when we go into the definition, equipment falls to be defined under the word device. So I wish to agree with the Children's Authority, and that could perhaps be considered. Yeah, and those are all the questions I have, Chairman.
Thank you very much, Member Mitchell. I want to invite, we come back to the Children's Authority and the other members. I want to invite Member Sagram Singh Suklal to lead us off in relation to the Office of the Prime Minister, Gender and Child Affairs, and their submission.
Good morning, everyone, again. So I have a few, what I will do is, it's three major points that was put forward by the Office of the Prime Minister. So just for us to be able to ascertain and for me to get some clarity, I will go through each one individually. And I just have a few questions that may require some just further explanation and clarity. So one of the first positions advanced was that adult offenders should be distinguished from child offenders. While children must take the responsibility for their conduct, they generally lack the experience and maturity to form a malicious intent, right? So my first question is relative to that particular position advanced. I just wanted to know, in terms of distinction from child offenders to adult offenders, what exact factors do you believe should be distinguished in terms of, let's say, the type of behavior that are either not punishable offenses or are punishable but not with imprisonment? Maybe you could add some clarity for the committee's consideration.
If I may answer.
Yes, member. Ms. Cardenas Rostan would respond on behalf of Gender and Child Affairs. Thank you.
Yes, thank you, member. Member, I think the scenario we envisage is one where you have children who are not only victims, but also perpetrators, and who may really, the treatment of the offender, so we refer to them as a juvenile offender, in this case, should be different from that to an adult offender. So I know that in the Children's Act, there is provision for the courts to treat with child offenders in a different way than adult offenders. meaning the penalties are various, and they have the right to look at supervision orders, probation orders, and so on. Because as you'd appreciate, the younger a person is in terms of their development, they may naturally gravitate to engaging in this kind of behavior, especially in the school setting, that they share photographs and videos of behavior that would be considered sexual in nature. In addition to which, I think it has also to be said that young persons cannot consent to pornography being shared. So even though they may consent, meaning they may not object to it, in law, they cannot consent to the use of their image. This is something that even adults have to give permission when you're using a child's image in an advertisement or in some other magazine or ad. You need to give consent. The adult has to give the consent because the child cannot consent. So that's one of the things you want to look at. And I think in terms of a proper public sensitization geared towards that age group will be necessary, because at this stage, it will really be floodgates, a floodgate argument for the number of young persons who can be found guilty of that offense. So I think there would need to be a strong public awareness campaign for that to be addressed. But we're talking about the treatment of the child offender being treated differently from that of the child, of an adult offender.
Now, there's a critical point that you would have advanced, and during the course of the Senate debate on this bill, actually, two of our colleagues, Senator Thompson Aye and Senator Sean Sobers, they raised two issues relative to the distinguishing a child offender and a child perpetrator, and you did make mention of that, right? Previously. What I want to solicit from you and the Office of the Prime Minister's position, is it be based on a clear, is it that you would recommend to this committee that we consider looking at in the law, in the amendment, making that clear distinction, as well as look, so how we treat, so for example, I recall Senator Sean Sobers would have made the point that, for example, the penalty for children, once a child is a victim of the offense, that should probably be reconsidered. So it's at a higher end of the pendulum, for want of a better word, right? So I'm trying to so tell me, what are your thoughts on that?
Okay, so you are talking about a scenario where you have a victim that is a child.
A victim and a child perpetrator.
Yes, it should be that the penalty is higher for a child victim, for the simple reason that no one can reasonably expect that a child consents to having their photograph or their video used, unless the perpetrator, or as we refer to the child offender, is also a child. So an adult should know that a child cannot consent to the sharing of their image or video of them engaged in a sexual act. So yes, the penalty should be higher if the victim is a child. However, on the converse side, if the child is the offender, then the response that is set out in the Children's Act in terms of how the court treats with the child offender should be put into place, and there should be a reference to it, because then you would be able to guide the courts as to what are the responses available to magistrates and judges when dealing with the child offender who has shared the image or the video.
Okay, so that is just one thing I wanted to solicit. Now, a point that was also made on the issue of being influenced by their peers, right? And in line of contemplating an amendment now, which clause would you say in the bill that appears, the amendments that appear before you warrants our reconsideration? So your position advance was the influence. Now that to me respectfully is a policy decision, right? But if we could translate that now into sections, clauses, sorry, that you may want us to reconsider. Do you have anything to advance relative to that?
I don't think that the issue with respect to influence by peers is something that be dealt with in the legislation. Right. It's really a social issue. So I think education is what would have to be what would have to be looked at, and sensitization, as I referred to before. So I don't think that is something that would require an amendment to any particular clause in the bill, for the simple reason that, again, you're criminalizing behavior that is naturally occurring between children, and having regard also to the exposure to especially during the pandemic, use of online classes and the availability of phones and Instagram and all of these devices that they use. It would be a public awareness campaign that would need to be adopted to really address that. I think also with respect to close in age, I think we have that we usually refer to as the Romeo Clause. So that if you have children who are close in age, one is the perpetrator and one is the victim, that's addressed in the Children's Act as well, as to how to deal with that particular situation. Because again, children can't consent. It really doesn't matter whether or not they wish the behavior to take place. In law, they cannot consent to the sharing. They also fall under the within the definition of child pornography and sharing child pornography, which is an offense created as well.
Okay. Thank you very much. Of course, your submission is duly noted. If I may respectfully refer to Section 20 of the Children's Act, right? Now, I know that's not what is before us, but it's pertinent to the amendment that appears before that this committee is called upon to look at. Now, Section 20. So if as I said before, if we refer to Section 20 of the Children's Act, I'm just trying to pull it. It provides for exemptions for offense of sexual penetration of a child, right? I just want to solicit from you whether or not OPM is advocating or maybe advocating for a similar construct as used in Section 20 to be applied to this bill. Is that something that would be considered?
Well, that I hadn't really thought of it. See, what you're asking is whether or not we want to make it a defense that the perpetrator is a child. If I'm correct.
Right.
I do not think that is the policy position that we would want to adopt, because we would want to more have compliance in terms of not sharing what is pornography. It would be contrary to pornography then, the criminal activity that's prohibited under the clause, under the offense of pornography. So I don't think the two things would be aligned.
Okay. I just wanted to advance what the position would have been there. Now, in the bill that appears before us, if we would go to, if you may respectfully go to the proposed Section 44C1, right? Proposed Section 44C1, as it relates to children, it speaks to, so if I may read it, subject to subsection 3, a person commits an offense if he knowingly shares an intimate image of a depicted child in circumstances in which the depicted child has a reasonable expectation that, and it goes on to say what the child may have a reasonable expectation of, right? What I want to know is whether or not, I just want to solicit your opinion as it relates to that inclusion of a reasonable expectation that children may have. Do you agree with this particular, with the construct of a child having that reasonable expectation as it is placed there in this particular section? Or do you believe that it is something that warrants consideration of removing that reasonable expectation?
Are you speaking about voyeurism? I'm trying to follow in terms of the section.
Intimate image. Is as it relates to the sharing of an intimate image.
And the section is that you refer to?
Yeah, clause 44C, subsection 1.
44C.
Even though it was not within the comments that you all would have identified, the reason why I'm asking, of course, it's a child-related issue. And I just, as we have the benefit of having you all appear before us, just to solicit briefly what your position is.
I don't think I follow quite clearly the submission.
Just remember, maybe we could come back to it because it's not in the written submission, and maybe we can give the Mr. Agber the opportunity, not Mr. Agber, Ms. Rostan, the opportunity to reflect on it. And in the interim, I want to move to the submission from the Ministry of Foreign and CARICOM Affairs. And I want to invite Member Lakshmi Diyal to just lead us off on those discussions.
Thank you, Chair. Thank you to the Ministry for your comprehensive overview of the international conventions that would be tackled here. So I gather from your submission that you are pleased that we are fulfilling some of our treaty obligations. Let me get straight to your comments and recommendations contained in your submission on page 4. At paragraph 16, you mentioned people also have the right to expect privacy of their bodies and personal space, even in a public setting. Now, we kind of had a little discussion about this before, about the public setting and so on. Do you feel that the law needs to have stronger, well, this really does not apply at all to a public setting. Do you feel that in your knowledge, extensive knowledge of our international obligations and treaty obligations, that the bill falls short with respect to the right to privacy and personal space in public settings? And what would you suggest, how would you suggest that be dealt with, and could it be dealt with in this bill?
Thank you, Member. Through you, Mr. Chairman. That is indeed a very valid question, and we would have to perhaps look again at some of the instruments to see whether, and if so, how deeply it may be covered in the international instruments.
Okay, so would you be minded to do a review and send us further submissions in writing on that?
Yes, certainly, Member.
Okay, thank you. You mentioned as well at paragraph 19, you asked us to take into account certain things. You wanted to see perhaps an offense for financial gain. When you said the creation of an offense for sharing for financial gain, now it is an offense to share, whether it's for gain or not. Are you asking here that a more serious offense or a more serious penalty be imposed when there's evidence that this thing is done for financial gain, or that there's hacking and of your devices, specifically targeting a person in order to, like, let's say it's a celebrity or something, and the information is hacked or the images are obtained through hacking for financial gain?
Yes, Member, that is the intention.
Right. So not necessarily a new offense, but a higher penalty than you think should be applicable.
Certainly.
Right. We had that same conversation with respect to when you have minors being the victims, whether you would want a stiffer penalty. The TTPS, when they appeared before us, and we asked about whether or not we should have a stiffer penalty for law enforcement officers who breach the law, they thought the penalty was sufficiently high to cover, because there would be, you know, other repercussions such as job loss and all of that. But do you feel that, I mean, and this is a high penalty included in this bill, you think it needs to go higher, or do you think we need to create categories within the range so that someone who does this for financial gain would be automatically at the higher end?
Yes, Member, that is in fact our opinion. If I may also add, forgive me if it's already in the bill, but for persons, for example, who perpetrate one of these crimes against an adult who is of diminished capacity mentally, in such circumstances as well, I think perhaps penalties should be stiffer. I'm not in a position to say which should be the highest and so on, but I think that category as well should be addressed, and certainly when it's done for financial gain.
So, okay, well, I'll take a note of that. I think with someone who doesn't have the mental capacity of an adult, they would be treated in the same way as a child, but I would have to verify how the courts would deal with that under the Mental Health Act, and all of those things would come into play. But I take your point there. So thanks for that suggestion. Your second suggestion was similar to what national security said about reckless intention. When I raised the concern before about that being a little bit difficult to prosecute and the range of people that you may capture where you deal with reckless intention, if you go to if you include reckless intention as part of the offense, where people are just sharing things forward. What was the thinking behind, let me hear from you, what was the thinking behind the inclusion of reckless intention? And do you think it would assist us better? And could you specify where it would assist us, if so, with respect to international obligations and treaty obligations?
If I may ask Director Legal Services to provide a response.
Sure.
Well, the Ministry of National Security had responded to this aspect of it earlier. You know, because when we looked at reckless intention, we were looking at the state of mind where the person deliberately pursues a course of action disregarding the risks that follow. And in our discussion this morning, you know, you rightly raised the point that it's difficult from person to person sharing the image. But, you know, what we had in mind was that it would be more in relation to the person who triggers the sharing, right? To cause distress to a victim. And what we felt is that, you know, in terms of the treaties that we have signed on to, what we find is that, you know, these offenses against women, you know, the gender-based violence, they're not only in relation to a physical sort of abuse, but also in relation to a psychological harm that is committed against them. So that, you know, the whole intent of sharing the image should also be captured in the legislation.
Well, yes. And do you think that 22C then in the Act that deals with sharing, do you think that it's inadequate to meet our international obligations and treaty obligations in terms of what is expected? Because it does not include the reckless intent.
I think we may probably have to look at the conventions again a bit more closely and defer this response at a later time.
Oh, right.
Thank you.
Yeah.
Thank you very much, Member Lachmidial. We would come back to that. Thank you very much for eliciting the response, and we would welcome the written submissions. I just want to give, before we come back to all the stakeholders, just want to give Member Mitchell the opportunity to lead us off in relation to the submission by CreativeTT. Member Mitchell.
Thank you very much, Chair. CreativeTT, your submissions were a bit brief, but let me ask, with respect to the creative industry, photographers, photography in particular, do you play any part or any role in determining the standards of professional photographers?
Thank you for that question. Good morning, everyone. Member Mitchell, at this point, we do not. We have been approached by two associations that represent photographers in Trinidad and Tobago. Unfortunately, our budgetary allocation did not allow us to engage in the study that they had requested be put forward. So at this point, we do not represent them in that way, but we do recognize their importance and impact into the creative industries.
Are you aware of any standards that apply to professional photographers? And we're asking this question in connection with the taking and sharing. Would appreciate that photographers, some of them have commercial studios, and you know, they take photographs of persons, of paying persons, pregnancy photographs, photographs in bath suits, in skimpy underwear. And I'm not sure whether they are aware that before they take and they share, because some of these professional photographers may share on their pages in advertisement of the types of work that they can produce. I'm not sure, and we're not sure, whether they are aware that they need the consent of those who they photograph, whether in the studio, or there may now be situations where a photographer may be photographing an event, carnival, or a fete, or otherwise, where there may be persons who are skimpily clad or otherwise become skimpily clad. You know, perhaps they are inebriated, they're unable to give consent, and the photographers may take photographs and may publish. Or everybody's a photographer now, so they have their cell phones and they may take photographs of someone who, because of you know, the ingestion of alcohol and so on, may not be able to give consent. So do you see a role for CreativeTT in a sensitization campaign once this bill is promulgated, in ensuring that photographers know, you know, how this law now applies to them with respect to the taking and sharing of photographs?
Short answer to that would be yes. Certainly it is within our purview as the Creative Industries Company of Trinidad and Tobago to ensure that all our practitioners are aware of all the legislation that impacts them. And generally, usually around the carnival time, there tends to be a lot of workshops, webinars, etc., targeted to photographers, speaking to them about the fact of having to be accredited by NCC for taking photographs on the parade route and etc., as well as intellectual property issues that arise out of photography, particularly during the carnival session. And as you said, everybody is a photographer now. My mobile has a camera, and therefore I can take consent. So certainly we do see it as something that we can engage in terms of sensitizing our photographers, especially as we have the relationship with the two associations that tend to manage the professional and amateur photographers in Trinidad.
I mean, if I could just add one question to Senator Mitchell's intervention, because it's related, if I could.
Yeah, I just have one more question, but you proceed, Senator Richards.
Thanks. To Ms. McNichols-Stevens, I know Dion. Everybody at the table, I know Dion very well. Ms. McNichols-Stevens, the law is the parts of the law that clauses of the law that state in situations that would be expected to be private. Intellectual property issues aside, that's a different conversation to a voyeurism bill.
Agreed.
Do you think that scenario, even with Member Mitchell's assertions that, well, persons may be inebriated, may have persons run afoul of the law, even though they may be in a public space and not expected to be private, and also in the context of, and this is a stretch, I know, but I think wide, because I know how sometimes law could be over prescriptive. It says the reasonable sexual behavior is one thing, but the law is, the legislation is also has content about for sexual gratification, and persons may get sexual gratification, some taping someone who is dancing on the street in a particular way. You understand? How do we reconcile these issues? Because children dancing and people dancing, there are people who may get quote unquote sexual gratification from that, but it's in a public space. And do you think that caveat, that the expectation of, or the lack of expectation of privacy on the streets may be some sort of lacuna?
Well, I think it's a combination of both having to address it to the photographers, as well as it being a social issue that is way beyond what we could do as CreativeTT. certainly what I think we can do is sensitize photographers to the possibilities of flouting the law in this, as it relates to this amendment that is before us, this bill that is before us. But that is as much as I can say for now in terms of how we tackle the bigger social issue. That's a, public relations and social campaign, I think, solution.
Yeah, Chairman, last question. Ms. McNichol Stevenson, I want to give you a little bit of work again.
Sure.
I would like if you can submit to the committee now the law as it applies to these situations that I'll now describe.
Mm-hmm.
You know that media photographers would be in a public place, in a public street, and would take a photograph of someone doing something or just proceeding along their merry way. And that person may say, you cannot take my photograph.
Mm-hmm.
The media person will say, yes, I can take your photograph. And the person may slap it away or become aggressive. Or you see also where a policeman in the execution of his duties would be photographed by an onlooker who is not impeding that policeman in the execution of his duties. And the policeman will say, no, you can't take my photograph. Perhaps aggressively slap away the person's phone or do something otherwise in aggression. Could you please, submit to us the law as it relates to photography in a public place, if you can?
Okay. Is there a timeline by which I should submit this?
As soon as you can. And I'm just asking you just because, we've had this discussion about photography and photographs in a public place, etc. If you could submit that to us just for our edification.
Sure, will do.
Thank you.
Thank you.
Thank you very much. Is Member Richards still with us? I know he had to leave. I now want to go back to some of the areas that we've covered so far, and I want to invite the members who have other questions to ask of our stakeholders. You have the Office of the Prime Minister. You have a further submission to make. Go ahead.
Chair, thank you, Chair. While we were having that discussion with Ms. McNichol Stevenson, we didn't have this in our submission, but there was one question concerning the issue of sexual gratification and 22A. Given that the offense is premised on this whole issue of obtaining sexual gratification, just for my understanding, I wanted to find out whether we needed to define sexual gratification or it's already defined somewhere in legislation. It's just for my understanding and clarification. Thank you.
Okay, the committee will provide the clarification once we've consulted with the CPC's team. Is there any member who has a question for any of the stakeholders who are before us?
No, Chair.
Okay, I want to invite now, I want to go through the stakeholders. I know that we've asked questions on your submissions and we've made comments, but as we prepare to close, I want to go through the stakeholders and invite each of you to make any further submissions in relation to what you've provided to us. If there's anything you want to add that has not been explored so far. So I will start with Ministry of National Security.
Thank you, Chair. And Yes, thank you, Chair and members. Thank you for giving us the opportunity to provide comments or feedback on the amendments. I know Minister Mitchell would have raised an issue for us to examine, and the legal team on this end will in fact be looking at that, and we will provide in writing to you what our comments are.
Okay, thank you very much. I now invite the Ministry of Foreign and CARICOM Affairs.
Thank you, Mr. Chairman. Just questions that occurred to us after the submission was made to the committee. And one is, I know that the bill covers digital images and images captured by electronic means. But does the bill cover adequately or at all intimate images that are created by drawing, sketching, or painting or similar form, and that shared without the consent of the subject? Now, should I go to another, or should I?
Yeah, you could move on to your next one.
Is it proposed that the bill would cover at some stage audio recordings of persons engaging in private acts when such recordings are done without the consent of or knowledge of one of the individuals, or with a threat to share the audio recordings? And I have one more, if I may.
Yes, proceed.
Does the bill cover the responsibility for monitoring material on any potentially locally developed social media platforms? And I ask this because I'm not certain that social media platforms are covered under the Internet Service Provider definition. Thank you.
Right, thank you very much. What I propose to do on these questions relating to drafting, in fairness to the CPC's team, I would allow them to, we've taken note, I'll allow them to consider it, and we'll provide the responses at a later time. So we've taken note of the questions. I just don't want, because in some cases we'll be treading on policy issues, in some cases we'll be dealing with consistency across laws, and in some cases we may be dealing with consequential amendments. I don't want us to go into those drafting technicalities at this stage. So we've taken note of the questions, and we appreciate the level of detail the stakeholders have gone into. I want to now invite the Ministry of Social Development and Family Services. And I want to ask the ministry, there's one in your submission, there's only one area that I wanted to ask about, and that is your recommendation in relation to section 44B, subsection 4A, that the exemption of the professional legal advisor who shares an intimate image, that you are suggesting, you're recommending that this exemption not be extended in the case of images of children. So Ministry of Social Development and Family Services, that is one question that I have to ask of you. And then if there's anything else you want to share with us as we head to the close, you're free to do that now.
Chairman, the only reason why this is being recommended is because of the existence of the Children's Act and the fact that children cannot, under no circumstances, give consent. And it's is supported in our reason where we indicated that since children cannot give consent, those fines should be very high for perpetrators of this offense. Just to add to what the Ministry of Foreign Affairs indicated, we also want to maybe consideration should be given to those persons who live on the street or street dwellers, and the services for those who are perpetrators, so that we address that somehow at either the level of the organization or the legislation. Those were the only two areas that we wanted to add.
Okay, thank you very much. Before I invite Member Lakshmi Dayal, I just want to correct something I had been saying all along. So the legal team we have supporting the committee is from the Office of the Honorable Attorney General, and those are the Law Reform Commission and the Criminal Justice Unit. So Member Lakshmi Dayal, thank you.
Sorry, Chair, I think my hand remained up from previous, but as I have the option, I just wanted to point out and ask the Ministry of Foreign Affairs, Foreign and CARICOM Affairs, if they could look, they asked about basically for blackmail. And I just asked them if they could follow up in writing with whether they think section 22B(1)(d) is sufficient, and if they have any further comments on that one, because it's related to their comments.
Right. Okay. Thank you very much. Thank you very much, Member Lakshmi Dayal. I now want to invite the Office of the Prime Minister, if you have any closing submissions to make.
Thank you, Chair. I would have given my comment, but I do think there is one other comment from Ms. Cardenas Rosta concerning persons with mental and other types of disabilities. Ms. Cardenas Rosta, you want to share on our behalf? Thanks.
Thank you, yes. So there are really two issues in terms of persons, and I think someone had raised it with diminished capacity. So perpetrators with diminished capacity, such as persons with Down syndrome or autism, who in terms of the voyeurism, this is the offense of voyeurism, that they be treated differently because of their inability to meet the mens rea for committing the offense. I don't think they were captured in the act sufficiently. And lastly, in terms of intimate partner relationships, that consent would have been given originally. Let's say, for example, boyfriend and a girlfriend, and consent is given to take photographs or videos, and then the relationship deteriorates. I think that consent should be automatically revoked because you would have originally given consent, but it is fair to say that if the relationship has deteriorated, the consent is withdrawn. And I think that is not covered in I'm subject to correction, but I think that's not covered in the amendment to the bill.
Okay, thank you very much for those submissions. Thank you, Office of the Prime Minister, Gender and Child Affairs. I now want to invite the representatives from the Children Authority to make any closing submissions that you may have.
Thank you, Honorable Chair. I just want to amplify our submission regarding educational purposes under Section 22. We are respectfully of the view that Section 22A(3)(b), so as it stipulates that a person who does not commit an offense under this section, if the acts that are alleged to constitute the offense are B, carried an authorized person for medical, forensic, scientific, or educational purposes, we are respectfully of the view that we should also qualify the persons identified here by reference to their acting in the course of lawful duties, as it is with the police officer in subsection A.
Okay, thank you very much. Your submission is noted. And as we close, I want to now invite CreativeTT, in the event you have any closing submission.
No closing submission, Chair, but to say thank you for allowing us the opportunity to contribute.
Thank you very much. So I want to thank first the stakeholders who made the effort to provide written submissions, very detailed and incisive submissions, and to also come before us and assist us in understanding your submissions and understanding our own position in relation to what you have submitted. I want to thank the support from the Office of the Honorable Attorney General and our parliamentary staff. I want to thank the media and all the other persons involved in, particularly the IT people and the persons involved in this broadcast and the recording. I want to thank the viewing and the listening audience, the people who were following on ParlView Live and the people who would follow the delayed broadcast later today. And at this moment, all that's left for me to do is to adjourn the meeting. Thank you very much.
Thank you, Chair.
Thank you.
Chair.
Thank you, Chair.
Thank you,
And
Chair.
members. Thank you.